안녕하세요. 저 스칼리 변호사입니다. 오랜만입니다. 오늘은 아주 특별한 주제를 갖고 저희가 이제 웨비나를 하게 됐는데, 이제 ADA, 아까 말씀하신 ADA, American with Disabilities Act에 관해서 특이한 법인데요. 이 점에 대해서 오늘 저희가 웨비나를 하는데, 이제 두 가지가 있습니다. 한 가지는 이제 Physical ADA Violation이라고 해갖고 거울이 너무 높다, 파킹plat이 안 된다, 이런 피지컬에 관한 ADA 바이올레이션이 있고요. 또 하나의 웹사이트에 관한 ADA 바이올레이션이 있습니다. 그래서 이 특이한 법에 대해서 누구한테 해당되는지, 어떤 사건들이 있는지, 그리고 사건이 나면 어떻게 이거를 해결책이 어떻게 있는지, 무슨 옵션이 있는지를 오늘 웨비나를 통해서 저희가 차근차근히 설명해 드릴 거고요. 오늘 저희하고 같이 이제 패널리스트를 이제 모실랬는데, 한 분 한 분씩 제가 소개해 드리겠습니다. 한 분은 이제 제 동료 변호사인 셰인 싱이라는 변호사님인데요. 이분은 이제 우리 노동팀에 있고, 그리고 이분이 말씀하실 거는 이제 ADA 그 웹사이트에 대해서 말씀해 주실 겁니다. 그리고 또 다른 동료 변호사 하이디 인맨이라는 변호사가 이제 조인하실 건데, 이제 이분은 이제 physical ADA 케이스에 대해서 이제 말씀해 주실 거예요. 그리고 우리가 물론 사건들도 나지만 이거를 사건을 어떻게 막을 수 있는지, 앞으로 이거를 해결책이 뭔지를 도와주기 위해서 이제 여기에 관련된 ADA 컨설턴트들 모셨습니다. 한 분은 이제 그 physical ADA consultant Karen Haney, 이분이 회사는 Compliance Design Consultants에서 나오셨고요. 또 다른 분은 이제 그 웹사이트 AD 그 컨설턴트인데, 이분이 이름이 제이슨 테일러이고요. 이분은 Chief Innovation Officer, 그리고 컴퍼니 이름이 유저넷이라는 데입니다. 그리고 마지막으로 이제 저희가 프레젠테이션 할 건데, 이제 주로 영어로 할 거예요. 그래서 마지막으로 저희가 서머리를 이제 한국말로 해드릴 텐데, 어, 어, 다행히도 이제 우리 그 한국에서 오신 김경수 변호사님, 한국의 백해맨리 로펌에서 오셨는데, 태평양으로 하죠. 태평양 로펌으로 오셨는데, 이분이 이제 이걸 간단하게 서머라이즈를 이제 좀 한글로 한국어로 해주실 겁니다. 그래서 매일 먼저 그 하이리 변호사님을 초대해 갖고요. 이분이 먼저 ADA 케이스에 대해서 말씀해 주실 겁니다. 하이리, you're up.
Good afternoon, everyone. Thank you guys for joining. We'll talk a little bit about how to avoid getting sued at all for an ADA construction architectural barrier. So if we could flip to the first slide. All right, so first off, what is the ADA? The ADA prohibits exclusions of people with disabilities from everyday activities. Next slide. First off, that's traditionally what you might think of as disabled individuals, but it also includes anyone else that is accompanying a disabled individual, such as their parents or perhaps their grandparents, whoever else might be associated with a disabled individual at the time, and anyone that's possibly subject to retaliation for assisting someone who is currently suffering from a disability. Next slide, thanks. For public accommodations, in case you don't know, anyone that is providing public accommodations is subject to the ADA. Per the ADA, no individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. And as an example of that, something that you may not traditionally think of, but restaurants that offer anything where they're assembling food for you, and if you have that food assembly line and someone that's in a wheelchair cannot visually see what's happening, but someone from a standing height can see what's happening. that could potentially be a violation, something that you should be considering when you're setting up your restaurant, when you're setting up anything where you have something that's interactive with the customer. You want to be able to assure that anyone that's in a wheelchair, anyone that's disabled in some fashion can also participate in that equally, just like any other customer at your business. So any public accommodation, this means any business establishment open to the public. Also, any establishment or place to which the public is invited or intended to public use. Broadly defined, this includes hotels, motels, spas and resorts, movie theaters, shopping centers, restaurants, and even RV parks. Anywhere that you are offering that anyone in the public can come, any space that is publicly accessible is subject to the ADA. Title III requires businesses to facilitate access by modifying policies, practices, procedures, sometimes providing auxiliary aids and services, and in some instances that I want to focus on today, removing architectural barriers. The example that we provided is if there's a fast food restaurant that's not providing table service, it may modify that in order to help someone that's a disabled customer. And so in the event that someone is disabled, well, you traditionally might call out the number or, have someone come to the counter. If they are not able to come to the counter to pick up their food or carry their food, you would then need to have your employees trained and be able to offer that assistance where they can take the food directly to them, directly to their table. Things of that nature, things that you're not thinking about necessarily. Obviously, it's not every day that someone who is quadriplegic may come into your business, but on the occasion that that happens, your business should be able to accommodate them and be able to treat them just like anybody else with the assistance that they may need in the event that they are requiring service from your business. The standards for the removal of architectural barriers are complicated. What the statute refers to is anything that is readily achievable. Readily achievable is anything under the statute that can be easily accomplished and able to be carried out without much difficulty or expense. For the most part, for most businesses, that's going to depend on the size of your business and the amount of money the business makes per year. Obviously, a very large business like Walmart or something that is nationwide is going to be expected to be able to remove any barriers that are there because they're a big enough company. They should be able to absorb the cost, and that is what a judge and a jury is going to consider in terms of whether a barrier should be removed. And in some instances, there will be very expensive measures that may need to be taken to get something into a situation where you've been able to remove the architectural barrier, but there are also some things that essentially the courts and judges have agreed that these things are readily achievable. So we get to the next slide. So examples of this are installing ramps. So if you have a sidewalk without any curb cut, you're going to be expected to install a curb cut and make sure that it's appropriately sloped, make sure that there is a way into the business. If the business only has stairs, you may need to have a ramp so that someone with a wheelchair would be able to get access to the building. Even a small step or a small stoop is going to require some type of a ramp if that is the only means of access into the building. Another thing that is considered readily achievable is widening doors. Doors need to be a minimum width entrance in order for them to be accessible for someone with a wheelchair. So if you have a business with a door opening that is not sufficiently wide, you will be expected to get that widened to be able to make it handicap accessible. Installing accessible door hardware. You may have noticed that businesses do not have a lot of doorknobs. Anything that requires grasping, pulling, turning, things like that may be more difficult for someone with a handicap. So in those circumstances, you're going to want to make sure if there's any knobs, anything in your business where someone may have difficulty accessing that door, you're going to want to get that door handle changed. Installing grab bars in toilet stalls is typically considered a pretty easy measure that people can undertake. So that is considered something that needs to happen as readily achievable. Insulating the lavatory pipes under your sink. Anytime there is an exposed sink with plumbing and a drain line, those pipes should be wrapped and insulated to prevent anyone in a wheelchair from having come in contact with a pipe that may be too hot from hot water through the pipe. Installing full-length bathroom mirrors. If, for example, you only have a mirror that a person at a standing height would be able to use, you're going to want to install a full-length mirror in that bathroom so that someone who might be in a wheelchair can be able to use the mirror. That also includes repositioning any soap dispensers, any paper towel dispensers, any coat hooks. You know, you put a coat hook on the back of the door at a certain height. If it's too high for someone in a wheelchair and it's not accessible, that's technically a violation. So you'll either want to remove the coat hook altogether or make sure that you have a secondary hook at a level where someone that's in a wheelchair would be able to get to it. Creating and renovating parking spaces is another one. Parking spaces have very specific rules and guidelines that need to be met in order for them to be accessible, but parking is required under the ADA and it is considered readily achievable, even though it may be a capital expense for the business. And another thing to be very mindful of is there are different regulations that will apply for your accessible parking spaces, access aisles, and ramps. For example, there is the ADA, which is the federal statute. There is state, which currently we're in California, and California has a different set of rules than the ADA. And there may be additional requirements from your local county. I reside in San Diego County, and it has additional requirements on top of the federal and California state requirements for accessible parking spaces. So you want to be sure to educate yourself, depending on the local rules of your county and jurisdiction that you're in, to be sure that you're in compliance with those accessible parking regulations. One of the reasons it's really important to do that is because anyone driving by your business might be able to see something that's out of compliance, and that will trigger a lawsuit. And we also need to be mindful not to rely on a general contractor to comply with these rules and regulations. You might think that you're safe and that you're protected and you're doing everything correct because you are hiring a contractor to go ahead and design and implement these parking spaces for you. But I will caution you that unless you are hiring someone with a specific expertise in accessibility, they may not put it in correctly. So be very careful about who you are hiring to do this type of work. So we'll talk a little bit about what the ADA does require and think a little bit about the parking at your businesses now, to the extent that you have parking at a business. The ADA requires a minimum width for the handicap spaces 8 feet wide, which is measured from the center of the blue stripe. And keep that in mind, because if you're trying to maximize your parking, you will need to make sure that you have the correct amount of width. The access aisles have to be a minimum of 5 feet wide for a vehicle, but 8 feet wide for van accessible spaces. And the maximum slope that you can have within the accessible parking space is 2%. Van parking also requires a 98-inch overhead clearance, which is a very high clearance. So keep that in mind if you're putting any handicap spaces underneath any awnings or trellises. You're going to want to make sure that you have that 98-inch clearance overhead. One note about access aisles, the access aisle itself next to the vehicle should be flat, and it should connect to a curb cut in a sidewalk. In some older construction, there are ramps in the access aisles, but those would not allow someone in a van accessible situation to be able to deploy the ramp from their van. So you want to make sure that your access aisle next to your van parking space is flat and level so that if someone is deploying a ramp, they'll be able to exit the vehicle safely. Now we'll talk about the California rules, which are slightly different. So the California rules, the parking space minimum, the minimum is 18 feet in length, 9 feet wide, which is an additional foot on top of the ADA regulations. The access aisle is a minimum of 5 feet wide, and for van parking, the access aisle is a minimum of 8 feet wide. Similarly, it also requires a maximum slope of 2%. The California rules recommend blue border lines for your parking with a blue accessible symbol. They also recommend your access aisles be hatched with lines across, and they have a clear marking that says no parking. And you may have additional local, county, or city requirements that you need to correspond with as well. So be sure that you check with your local city. A lot of them have those rules and regulations right there on the county and city website. So be sure to check those to make sure your parking is in compliance.
Heidi, I'm sorry. I think we're running a little behind schedule.
Okay.
So can we move on to Karen? This is a pretty good segue.
Perfect.
Okay, thank you, Heidi. Okay, so Karen, you're up.
All right. I think Heidi did a good job of discussing some of the general requirements for accessibility and also explaining that it is complicated and that there are at least, 2 significant regulations that you need to comply with, the ADA as well as the California Building Code. So our company is a disabled access consulting firm. I'm a certified access specialist in the state of California. And so what we do is we do inspections of businesses to identify any areas where the business is out of code with the ADA and the California Building Code. So you understand what issues you have and what alterations you need to make, as long as those alterations are considered readily achievable for the business. We do an inspection, we provide a report, and that way you can start working on removing architectural barriers at your property so you can avoid the costly lawsuits. And in addition to what Heidi said, there are very many lawsuits for accessibility related issues because these requirements have been around since 1992. So the accessibility upgrades, you've had, over 30 years to remove things like knob door hardware, or to lower your dispensers in your restrooms, or to provide accessible tables at your restaurant. So it's hard to defend not making those alterations. So I think we do need to move on to the website accessibility, but just to let you know that there are companies that will come out and do an inspection of your business to help you to comply with the physical accessibility regulations of the ADA and the California Building Code.
Thank you, Karen. Shane, are you ready to move on with the website ADA issues?
Yes, thank you. And thank you to everyone that helped put this together in the KITA organization. So this presentation that I'm about to do in about a 15-minute, it's really more for an hour. So if anyone has, any questions, feel free to follow up after. And we're not going to obviously be able to go through all the slides, but I want to make sure I hit the bullet points that we need to. So with that, can we move to the slide that reads background concerning Title III of the ADA? And we can move to the next one. And so similar to what Heidi was talking about, the same basic rules, the big picture rules about ADA and access to disabled apply, but obviously in a website situation, we're dealing more with audio and visual impairments rather than the physical barriers that we were talking about. So here's kind of the problem is like everyone has a website, right? Whereas everyone may or may not have a brick and mortar store. For example, there's websites for everything. There's websites for civic organizations. There's websites for retail businesses. There's websites that provide information to go visit a city. And then oftentimes you hear of these lawsuits. And after me, we have a company that does provide services to help improve your website. And they, keep data and some of these other things that they're going to speak about on this issue. But I like to start when I give this seminar. One thing I like to talk about, people always ask, like, what causes a website not to be compliant? And there's different ways a website can't be compliant, but in my experience of having worked on these for a long time, the number one reason why a website is sued is that an individual, mostly a person with a visual impairment, cannot read a picture, either if it's some kind of a picture format or if it's a PDF format. Because people with visual impairments, they utilize readers. And these readers are software that could read word and text, but when it sees like a PDF or a picture, it's just a blank screen. And in order to be compliant for the most part, and to be able to defend against a lot of these lawsuits, a website has to have descriptive text. So if it's a PDF document, maybe there's a Word version of it where the reader can read, or if it's a picture, there's a description like, oh, we're looking out to the sun and there's a mountain and there's a sky or something to that effect. That's usually compliant. But with that said, I have a war story that I like to talk about, and some of my clients find it entertaining. I had a case where this particular organization, they actually did spend a lot of money developing their website at the beginning, and were fairly confident that it was going to comply with all applicable laws and regulations. And they wanted to fight the case. And as an attorney, obviously, it's something that we like to do. And we do like to, win these cases when the facts present themselves and it's the right kind of case. So I'm taking this woman's deposition, who's the plaintiff in the case. And when we're going through the deposition, I ask her, so ma'am, what type of, who is your reader? And normally in working on these cases, that they tell you the type of software. And one of the main companies is JAWS. And then there's other companies that do this software. And the woman was like, no, I have Susan. And I was like, Susan, I've never heard of Susan. Can you let me know about Susan? And she was like, oh yeah, it's a lady, a human that came to her like 4 or 5 times a week and helped her use the computer and would actually be the reader that would read the stuff. So in that circumstance, there's no violation, because if there's a picture, there's a PDF, the human reader could read it, right? And I mean, needless to say, the opposing side dismissed the case at the deposition, and we won the case that we were trying to litigate and get it ready for trial. So that stuff does happen. It probably would be the most rare of occasions, but it does happen. Can we move to a couple of slides? The one right past where it says Department of Justice fails to come to the rescue. There's a bunch of examples in text. And again, this is from a longer presentation, but I wanted to give you a quick overview of this. So when Heidi was doing her portion of the presentation, Heidi spoke about standards and regulations. For example, a parking stall has to be so many feet wide. The problem when we're talking about websites is the United States Department of Justice, despite constantly every several years saying they're going to issue regulations that deal with websites, have not issued these regulations. So there's been draft regulations and other things. So the problem with this is that without actual standards, the courts in America have adopted all sorts of guidelines that various nonprofits have adopted or promulgated, and WCAG is one of them. And I know we'll talk about it a little bit at the end of this program, but that makes it challenging because we have these lawsuits under the ADA seeking the remedies that the ADA provides, but when it comes to visual or hearing, there's actually no black and white regulations that the ADA has implemented. So you always have to be kind of mindful about who you go with and counsel you seek and experts you seek that actually spend time and keep a track of the changing environments and what does comply and what doesn't. So that's kind of the murky part of what you end up having to do to get a website. If we could go a few regulations to who is subject to the ADA. And similar, it's several pages down, similar to what Heidi spoke about. There's a bunch of different types of websites that end up being included in this. But at this point, I just think it's important to talk about where these lawsuits occur, because if you go to a store, right, you go to a store in Los Angeles, the lawsuit's going to be filed either in Los Angeles or it's going to be filed in the federal court in Los Angeles. But your website, someone can avail themselves to the website anywhere in the world, correct? So even with that, most notably, the website cases are filed in New York, in the federal courts in New York, or in California in the state or federal courts. The lawsuits that are filed in California, they ask for the relief to fix the website so it's fashioned for the individual. But the additional part they ask for in California, and you have to be really careful, is California state law entitles an aggrieved person $4,000 in state UNRRA damages. So oftentimes they'll ask for the website to be fixed. Then they'll ask for $4,000 for this person. And the initial demand that you might get, they'll say, oh, dear website, sorry, we cannot access it. My person tried to go there 4 times. So they're going to want $20,000 to pay this guy that couldn't access the website 4 times. So obviously you have to analyze it, understand what the allegation is, and see how you can minimize the $4,000 in California statutory damages. But the one's not really great good news is, but California law recently, case law has said that if they want these damages for a website in California, they actually have to have a physical presence in California, like a physical location, retail spot or something. So sometimes that helps protect folks from the state court damages in California. One thing I have seen more recently is that litigation has occurred. So some of the cases have been favorable. Some of the cases have not been as favorable. So in my practice, I have seen a lot of demand letters come in. The client, correctly comes to our office, talks to us about it. And I'll be honest with you, I've been making a few phone calls and been able to settle these cases, the ADA website type recently, for nominal amounts, because once they see that there's an attorney on the other side that has actually worked on these cases for years and understands the potential defenses, they'll settle these cases without even going to court, and for very nominal amounts. I mean, even less than it would take to really, build up a defense in the case. So that's kind of a trend that I've been seeing. That's actually, if you get one of these, it's not as bad as if you got one 2 years ago, but still you have to be mindful of that. Just to be careful with how much time we have allocated in this. Using services that the speaker is going to talk to you about in a minute, it's sort of the only way to kind of help prevent these lawsuits, because websites change all the time. And when websites change, sometimes the information that was already on there is still there, whereas something new changes that might affect it. And for a lot of my clients, how this occurs is that initially they'll go to a website that's like the big company. For example, I represent a lot of hotel franchisees. But until it gets to the franchisee, it has to go through the franchise or's website until you're at the very end stage where it's on your location. So sometimes you need to take a look at these cases and figure out where the violation is. And in this scenario, sometimes it's not even our part of the website. So we just, do a nice little correspondence to opposing counsel saying, this part of the website is controlled by others. And normally it might be okay if someone checked your website out 2 weeks ago, but something outside of your control gets involved and affects the website, so it can affect whether or not you have a case against you. And the folks that are bringing the case, the folks that are doing the demand letters, there's absolutely zero way for them to know until your attorney gets involved and is able to educate them on it. Another thing we have found over the years is that oftentimes our website will link to other websites. For example, you have a business like a skincare office or like a med spa, but there's a product that you provide, a service that you provide that has a YouTube video. Well, that YouTube video is linked to the manufacturer. You have to be really careful, because on your website, you'll have a link to that video. But your website is fully compliant, but that video may not have the necessary closed captioning. So a deaf person navigates to that from your website. Now they're going to bring suit against you. So there's a lot of moving parts on website ADA litigation. And so it's very important when you get a case that you find the right attorney that can know how to navigate your case and figure out what court it is and what court it's not in and how to handle it. Then also get the support you need from the IT technical part to provide the necessary resolution so you can prevent these lawsuits. We have just a couple of minutes before my time is up, and I get asked this question a lot, and this question is that a lot of times when these lawsuits are filed, they're mostly filed in the ones that are in the New York jurisdiction, and clients really get nervous because a lawsuit on paper will say class action against company X. I just want to make sure that if you do get this or know someone that does get that, the attorneys on the other side, they're never looking to make it a class action. They try to use that wording to get a rise out of the person they're proceeding against. And they never actually go through the class certification process or notifying anyone that had used your website that might have a visual impairment, because there's really no way to find out exactly who was on your website that had an accessibility issue with regards to visual or audio. So that never happens. I do get those frantic calls all the time from clients with the website, but generally speaking, it never manifests itself to a class action case. Other than that, I think this is probably a good time for us to go to discuss with our website vendor.
Perfect. Thank you, Shane. Jason, please take over from here.
Thank you, guys, and thanks, Shane, to introduce the subject. I believe I have a couple of slides, but I think Shane and also Heidi's done a great job of getting, probably, if you own a business, you're now a little bit scared that you might get a lawsuit. So, in the same context that Heidi talked about, and I think, guys, if you could try to find the slides, I just wanted to give people an idea of how popular is it to sue a company for websites as opposed to what Heidi was talking about is like physical spaces. And essentially, the number of lawsuits against websites today probably is almost the equivalent as physical. So last year, there was over 4,000 lawsuits against companies that have a website that people claim they can't use.
I think the slide we need to be at, it says about usablenet. It's towards the very end of the slides.
Thank you, guys, for finding the slide. So usablenet essentially helps companies make sure that they're doing the best they can to support people with disabilities, and at the same time, guide our clients on trying to be compliant as possible under the ADA. I think Shane did a great job of saying that there's lots of things that you probably, as an owner, you wonder why, you wonder what you got to do. So the first thing I would do is, I don't know much about the companies here, right? So how can you avoid a lawsuit against your website? And if you can go to the next slide, Shane did a great job of explaining what a typical claim looks like. It's made by someone who's blind. About 95% of them are basically brought by someone who's blind, who says that they can't use the website like everybody else. Rather than get into the technical side of, hey, what do you have to do? Think of that as basically someone saying, hey, I can't use your website as good as somebody else. As Shane said, there's a lot of things that they probably can find on your website that probably creates problems. This is not 4,000 individuals suing 4,000 companies. This is a plaintiff bar activity. This is 80% of the lawsuits are brought by the top 10 plaintiff firms and the top 15 plaintiffs. So they are generally, as Karen said, looking for issues on websites. So in the same way that Karen talked about people driving past your property and finding a parking space that doesn't fit the requirements, there are plaintiffs and plaintiff firms surfing websites to find out if they've got problems. So if you're a company owner, and I would break this down into what could you do to help yourself right now to sort of get ahead of this potential lawsuit. The first is, if you're very small, do you need a website? Do you need a website, or could you survive with only being on Open Table, only being on LinkedIn, only being in some other bigger format areas, and not need a small website. I say that candidly. If the website that you've got is sort of like something that sort of seems to be something they should have, but doesn't generate a lot of business for you, you might want to consider how else could we promote ourselves as a property or as a business without using our own website. That was the first way for you to remove yourself from being sued because someone says they can't use your website as well as somebody else. The second is most people didn't build the website themselves. You paid somebody to build your website. Go to that company and ask them, what do they do to make sure your website's accessible? Put pressure on them because you pay them money to put you in a good place. If you don't have a great relationship with your current provider, go to a new provider and make it part of the procurement. So if you're a little bit bigger of a company and you're thinking, hey, we need a new website, or we renew our website contract every year, make sure that this is part of your requirement. Now, as Shane said, that doesn't stop a lawsuit, but it should help you avoid a lawsuit if someone's taking note. And if you go to the next slide about like what you could do to sort of avoid lawsuits, right? The good news that Shane has brought is that what the plaintiff does is quite limited in terms of to try to identify what's wrong with your website. So you should be making sure that the people who look after your website are doing at least the same as the plaintiff firms, doing the same type of tests. For example, if you went to our company, which is UsableNet, there's a free test on the homepage that allows you to test your website. You probably might not even be technical enough to want to do that. Tell your web agency to do that. Tell who is ever in charge of your website to go to usablenet.com, test the website, and whatever you find there, get them to fix. Because that's what lawsuits are built on. They're built on things that are easy to find. The good news is generally most of those things are easy to fix. So I would encourage you to basically put pressure on the people that you pay money for to make sure the website fixes. As Heidi sort of indicated, but it's your website. So, you do want to make sure that they know what they're doing. You are still liable for it. But if you're a bigger company and you've put it into the contract, at least you have something to somebody to sue if it does cost you something. And then the final thing I would tell you, which I think is very important because Shane talked about it, if you do get a demand letter or a lawsuit, do engage a company like Shane and Lewis that know how to handle these plaintiff firms. As I said, 80% of them are brought by 10 plaintiff firms. So Shane knows what they're looking to do. He knows what they're trying to achieve. Rather than if you hire a lawyer that knows nothing about this space, they don't understand the playbook that these plaintiff firms are using. So that's my only last advice is if you do get a lawsuit or a demand letter, make sure you reach out to counsel that deal with these plaintiffs all the time because they're going to give you a roadmap of how best to deal with it. I hope that was helpful for everybody, and I do appreciate everybody's time.
Thank you, Jason. 김경수 변호사님 준비되셨습니까?
네, 진행하겠습니다. 지금까지 많은 내용을 했는데 간단히 요약하고 한국의 상황과 좀 비교해서 간략히 말씀을 드리겠습니다. 일단 한국에서는 이런 소송이 별로 없어서 이게 좀 생소하실 수 있습니다. 그 이유는 한 두 가지 정도를 생각해 볼 수 있는데 일단 한국에는 이와 같은 장애인의 접근권이나 이동권에 관한 규정이 좀 충분치 않거나 있더라도 권고 수준에 그치는 경우가 많기 때문에 이런 소송이 일단 적은 상황이고요. 또 하나는 한국에는 원고를 전문적으로 대리해서 소송을 제기하는 플레인티프 로펌이라고 하는데 이런 로펌이 굉장히 적은 상황입니다. 그렇기 때문에 이런 소송이 한국에서는 크게 문제되거나 잘 발생하지 않습니다. 하지만 미국에서는 플레인티프 로펌이 많고 이들이 주도해서 제기하는 소송이 많기 때문에 한국에서의 상황과는 사뭇 다르게 됩니다. 그래서 이런 이유로 ADA를 포함해서 장애인 법에 대해서 어느 정도 아실 필요가 있다고 생각합니다. 만약에 요구사항이 준수되지 못할 경우에는 실제로 소송의 대상이 되고 그런 케이스들이 많이 있기 때문에 늘 이런 법령에서 요구하는 게 어떤 수준인지는 아실 필요가 있습니다. 그 모든 내용을 하기는 어렵기 때문에 앞선 발표에서도 나오긴 했지만 뭐 예를 들어서 장애인의 그 이동권과 관련해서 주차 공간이 기준에 따라 마련이 되어 있는지, 경사로는 잘 설치되어 있는지, 출입문이 여는데 지나치게 헤비하지 않은지, 화장실의 경우에 그 비누나 페이퍼 타월의 위치나 이런 거에 문제는 없는지 등이 전부 다 소송의 대상이 될 수 있기 때문에 그런 준수사항이 잘 있는지 정기적으로 점검이 필요한 상황입니다. 지금 말씀드린 거는 일종의 물리적 장벽에 관한 얘기였는데, 이거는 좀 구체적인 얘기가 많이 나왔었는데, 웹사이트 경우에는 굉장히 광범위하게 접근이 가능하지만, 구체적인 기준이 아직 마련되어 있지 않은 상황이라 더 리스크에 대비하기 어려운 입장에 있습니다. 기업들 입장에서요. 앞서 나왔지만 법무부 규정이 일단 없는 상황이고요. 법원의 결정도 이게 결정이 나오기까지 가기 전에 세틀로 끝나는 경우가 많기 때문에 이게 소송이 한편 만약에 제기가 되면 사건이 조기에 끝나지 않고 소송이 길어지기 때문에 기업 입장에서는 좀 대응하기 어려운 상황에 있습니다. 또 그 웹사이트의 특성 중 하나가 이게 웹사이트의 모든 정보가 특히 요새 들어서는 당연히 사진이라든가 지도라든가 이런 PDF 파일이 많은데 그게 관리자가 미처 발견하지 못한 링크를 통해서 그 정보가 접근이 해야 되는데 이게 읽어질 수 없는 상황이 되면 그 또한 위반 사항이 될 수 있기 때문에 웹사이트를 관리하는 기업 입장에서는 이런 소송 리스크가 더 크다고 할 수 있습니다. 이 소송은 앞서 얘기했지만 뉴욕이나 캘리포니아에서 소송이 많이 제기되고 있고 캘리포니아의 경우에는 이 장애인의 이용에 어려움이 있을 때마다 $4,000와 원고 측 변호사 비용을 배상하도록 하고 있기 때문에 만약에 이런 위반이 있는 경우 기업 입장에서는 이게 큰 부담이 될 수 있기 때문에 이 사전에 도움을 받거나 아니면 정기적으로 웹사이트의 상황을 점검하는 것이 중요하다고 볼 수 있습니다.
With that, I think our time is up. I want to thank our panelists for joining us today and making such a wonderful presentation. 모든 키타 멤버 여러분, 오늘 웨비나를 이로써 마무리했고요. 오늘 저희가 말씀드린 모든 프레젠테이션 매터리얼은 아마 키타를 통해서 받으시는지 아니면 저희가 보낼 수 있고요. 그리고 앞으로도 더 좋은 토픽이나 서브젝트 매터에 관해서 필요하신 대로 저희가 또 프레젠테이션 하겠습니다. 예, 이상입니다. 안녕히 계세요.